Hi there, I'm Kent Berk at the Scottsdale, Arizona law firm of Berk and Moskowitz, where we handle probate, trust, will contest, and other disputes in Arizona. I'm going to explain today what happened in the recent case decided by the Arizona Court of Appeals in the estate of Gloria Waterloo. This case involved a question of whether Gloria left a valid last will and testament that referred to a final list of instructions attached to the will, but which instructions actually weren't attached. What happened was Gloria was living in a hospice care nursing home when her friend Jack Zimmerman and his wife Sandy came to visit. Because Gloria was too weak to write, she explained to Sandy what she wanted in her last will and testament and had Sandy write it out for her. Sandy then read the terms of the document, and Gloria agreed with it and initialed each of the 5 short paragraphs and signed the document. The document referred to a final set of instructions that were attached, but they were never written. The final instructions were not attached. So Gloria died about a month later, and Jack sought to have her will admitted to probate when Gloria's heirs, her family, objected and said that because the list wasn't attached, it wasn't a valid last will and testament. The Superior Court, the trial court, agreed with the heirs and found that because the list wasn't attached, that it wasn't a valid last will and testament. So Jack appealed, and in the Arizona Court of Appeals decided that it was a valid will, since Arizona has a strong presumption of testamentary intent, and although the document was not perfect, what Gloria wrote out clearly reflected that she was giving instructions of what would happen to her property upon her death. Now, very importantly, though, the Court of Appeals did not decide how the will should be interpreted or construed or who gets what. The court said that those issues were left to be determined on remand after the case was sent back to the Superior Court. So by admitting the will to probate, the court did not find that how the will should be applied or who gets what. Those questions would be decided later by the Superior Court. So as far as I'm concerned, the moral of this story is, if you want to write up a will, make sure it's complete and accurate. Make sure that if you're going to refer to a final set of instructions, make sure that the instructions are actually attached to the document or don't include the reference. After all, if you write up a last will and testament, the whole point of that is to have certainty and clarity in what will happen to your assets after you die, rather than having litigation like what happened in Gloria's case, in Gloria's estate. You can watch our website, azestatelawyers.com, for further news and updates. And if you have any questions, please don't hesitate to give us a call. Thank you.